Welcome back to Deb's True Crime Notebook, where we read the documents for you so you don't have to. If I sound a little bit strange today, it's because I just got back from the dentist. My mouth is still numb. I hate that feeling. I know you guys know what I'm talking about. So if I sound a little bit odd today, that's the reason why. Okay, this is not going to read smoothly like other documents that actually are telling a story, but we're going to muddle through this anyway. In the Indiana Court of Appeals cause number, Richard M. Allen, appellant, defendant below, versus State of Indiana, appellee, plaintiff below. Notice of appeal, appearance. Party information, Richard M. Allen, appellant. And the telephone number, fax, email, etc. have been left blank. Requesting service of orders and opinions of the court by email, fax, or U.S. mail. Informa pauperis. Now, what informa pauperis means is that it's a Latin term, of course, and it's in the manner of pauper. So a suit brought informa pauperis allows a poor person to bring suit without incurring any cost. Basically, the state's paying for it, as in the actual trial. So that's what that means. Attorneys representing party filing notice of appeal, Mark Lehman, and it has his address. He's from Logansport, Indiana. It has his phone numbers. You can see that. I'm not going to read it. And also Stacy Uliana. She is from Bargersville, Indiana. Also, her information is there. Information for judgment order being appealed. Date of judgment, order of being appealed, 12/20/24. Title of judgment, order being appealed, judgment of conviction, sentencing order. Date, motion to correct error denied, if applicable, February 14th, 2025. If case was heard by a magistrate, date, trial, judge, approved judgment or order. That was left blank. Basis for appellate jurisdiction. Appeal from a final judgment as defined by Appellate Rule 2H and 9I. Appeal from an interlocutory order taken as of right pursuant to Appellate Rule 14A or 14D. Appeal from an interlocutory order accepted by discretion pursuant to Appellate Rule 14B3 or 14C5. Expedited appeal taken pursuant to Appellate Rule 14.1. This appeal will be taken to Court of Appeals of Indiana pursuant to Appellate Rule 5, Indiana Supreme Court pursuant to Appellate Rule 4. This is an appeal in which a sentence of death or life imprisonment without parole is imposed under the Indiana Code of 35-50-2-9 or a post-conviction relief case in which the sentence was death. This is an interlocutory appeal authorized under Rule 14 involving the death penalty of a life without parole case raising a question of interpretation of Indiana Code 35-50-2-9. This is an appeal from an order declaring a statute unconstitutional. This is an appeal involving a waiver of parental consent to abortion under Rule 62. This is an appeal involving mandate of funds. So what I've just read to you is a list of things this could be an appeal for. However, the only one that is marked is the Court of Appeals of Indiana pursuant to Appellate Rule 5, Indiana Supreme Court pursuant to Appellate Rule 4. Okay, so number 5, Appellate Rule 5 is the only one that is marked there. All the other things that we just read through were things that you could receive an appeal for. Doesn't mean it has anything to do with this case. Wanted to make that clear. All right. Trial court clerk, administrative agency, court reporter, instructions. Pursuant to Appellate Rule 10 or 14, the clerk of Carroll Circuit Court is requested to assemble the clerk's record as defined in Appellate Rule 2E. Pursuant to Appellate Rule 11 or 14C, the court reporter of the Carroll Circuit Court is requested to transcribe, certify, and file with the clerk of the Carroll Circuit Court the following hearings of record, including exhibits. The discussions, arguments, and testimony with exhibits on record during the hearings held of the following day, including the hearings held in the courtroom, whether before the jury or outside its presence, and all recorded proceedings held in the court's chambers. And it begins a list, starting with hearings that were held November 11th, 2022, hearings that were held all the way through January 13th, 2023, February 17th, 2023, June 15th, 2023. This is a list of all of the hearings, status hearings, and the dates, which was in October of 2023. Also hearings that were held in October, in March, in May, in July, and in August. If you recall those of 2024, those were last summer. Status hearings held in August, jury selection in October of last year, sorry about that, and all of the trial days all the way through November 9th. That's what this list consists of. That's what they're asking for information from. And then also through November 11th, 2024 and December 20th, when that was the day that he received his sentencing on 2024. Public access was the entire trial court or agency record sealed or excluded from the public access. Marked there as no. Was a portion of the trial court or agency record sealed or excluded from public access? Marked yes. If yes, which provision in the rules on access to court records provides the basis for this exclusion? ACR 5B2, case records excluded from public access are declared confidential by Indiana statute or other court rule. Indiana Code 3538-113, confidentiality of pre-sentence investigation report or memoranda. Code 353411, confidentiality of criminal indictment of information when filed under seal. ACR 5B7, records in the pending matter that pertain to the permissible ex parte proceedings, post-charging investigation, requests for process, or requests for in-camera review, and that have been ordered confidential by the trial judge. ACR 5B9, mental health records compiled or created by a mental health service provider for treatment purposes. ACR 5C, personal information of litigants, witnesses, and children. ACR 6A, if Rule 6 of the Rules on Access to Court Records provides the basis for this exclusion, was the trial court or agency order issued in accordance with the requirements of the rule? It is marked yes. No, the Indiana Supreme Court addressed this issue in its December 11, 2023 published order denying writ of mandamus and prohibition. Appellate alternative dispute resolution. If civil case is appellate willing to participate in appellate dispute resolution. And then yes or no was not marked on this. It says if yes, a brief statement of the facts of the case. And of course, yes or no were not marked. Attachments. The following shall be attached to this notice of appeal in all appeals. And this is marked. Copy of the judgment of order being appealed. The following shall be attached to this notice of appeal if applicable. Check if applicable. Copy of the trial court administrative agency findings was not marked. And then marked again as copy of the sentencing order in criminal cases. Also, order denying motion to correct error, or if deemed denied, copy of motion to correct error. Also, copy of all records or orders and entries relating to the trial court or agency decision to seal or exclude information from public access. Not marked was if proceed pursuant to Appellate Court 14B3, copy of order for the Court of Appeals accepting jurisdiction over interlocutory appeal. That was not marked. Marked is the documents required by Rule 40C, if proceeding in forma pauperis. Again, that means because he cannot pay. Sentencing order page 3, dated 12/20/24, and order of record concurring in appointment dated January 10th, 2025. Certification. By signing below, I certify that this case does not involve an interlocutory appeal. Issues of child custody, support, visitation, adoption, paternity, determination of the child in need of services, determination of parent or parental rights, or an appeal entitled to priority by rule of statute. It, again, does not include that. 2, I have reviewed and complied with and will continue to comply with the requirements of Appellate Rule 9J23F and the rules of access to court records on appeal. And 3, I will make satisfactory payment arrangements for any transcripts ordered in this notice of appeal as required by Appellate Rule 9H. Respectfully submitted, Mark K. Lehman and Stacy Uliana. And those are the 2 appellate attorneys. So they've made an appearance. They're doing all of the formal paperwork for this appeal, and everything is starting to roll forward. Certificate of Filing and Service. I hereby certify that on March 11th, 2025, the foregoing was filed with the clerk of the Indiana Supreme Court, Court of Appeals, and Tax Court. I also certify that on March 11th, 2025, the foregoing was served by United States Mail, postage prepaid, and it was served upon Honorable Francis C. Gold, Special Judge, the Clerk of Carroll County Circuit Court, the Court Reporter for Carroll County Circuit Court. I also certify that on this March 11, 2025, the foregoing was served upon the following by use of the Indiana Electronic Filing System: to Theodore Rokita, he's the Attorney General; Nicholas McClellan, we know he was the prosecutor; and Stacy Diener and James Luttrell, or Luttrell, I'm never sure how to pronounce that last name. Also to Amy Carrozas, who is in charge of assigning the appellate judges for the Supreme Court appeals; to Andrew Baldwin, Bradley Rosie, and Jennifer Auger. And it's signed Mark K. Lehman. So in our recap, it's going to be short and sweet. The 2 attorneys who are in charge of the appeal, Lehman and Uliana, have made an appearance now in the court system, and they have made requests for basically all the information for all of the hearings there were throughout the time Richard was arrested until he was convicted. And they are asking for all the information in that. They've stated what type of an appeal they're going to make, and the rest we'll have to wait for to see what they actually say and come forward with as strategic parts of the trial that were technically eligible for an appeal. Does that make sense? It's kind of tricky, isn't it? I know this was kind of cut and dry, not an easy read, but it's important, and it pulls us forward in the case. And hopefully in the near future, we'll know if there's an appeal or if it's been denied, and we can move on with our lives. Thanks for watching Deb's True Crime Notebook. Don't forget to like, subscribe, ring the bell for all notifications, leave us a message, and share this in your group and with some friends.